SJC-11525, Commonwealth versus Carter.
Mr. Solomon, good morning.
Good morning.
And we're all set.
Thank you. Good morning, Your Honors. If it pleases the court, my name's Attorney Russell Sobelman, and I represent Mr. Carter. And I believe one of the main issues on appeal is the lack of the manslaughter jury instruction, both under reversible error and substantial likelihood of a miscarriage of justice. I would suggest there was evidence during the trial that this was not an intentional killing. And
It seemed, though, as though the witnesses who testified about what happened made it sound very much like an intentional killing. Is that not so?
well, there was a variety of witnesses, and I would say there was conflict with the witnesses. Some would say there were so many shots, some said there were less. Some said the room was, how many people were involved, some said different amount. There was definitely conflict. So if you only wanted to accept certain statements, you might be swayed. On the other hand, if you wanted to just take the statements that contradicted that, you might be swayed depending on different issues.
What were the theories on which the Commonwealth prosecuted the murder indictment?
Joint venture.
But was it just felony murder?
Yes, I believe it was.
There wasn't a theory of deliberate premeditation or?
No, felony murder.
Okay.
But the verdict form invites the jury to choose deliberate premeditation and/or felony murder. So I
Right.
assume that he was only found guilty of felony murder.
Correct.
So if he's only found guilty of felony murder, and involuntary manslaughter is not a lesser included of felony murder, how is there a substantial likelihood of miscarriage of justice?
Well, I would suggest that the evidence warranted that, and because intent still has, it's only the malice that doesn't have to be proved.
Okay, let's assume you're right for the moment. Let's assume that the judge should have given a lesser included of involuntary manslaughter. That would be a lesser included only as to the deliberate premeditation, not as to the felony murder, correct?
Yes.
So the jury found him guilty of felony murder. So how would the presence of an involuntary manslaughter alternative have affected the jury's finding that maybe he didn't intend to kill him, or maybe we can't be sure beyond a reasonable doubt that he intended to kill him with premeditation, but he was a joint venturer in an armed robbery which resulted in the death of the victim, and therefore we find him guilty on that theory.
Right. The way I construe or interpret Pagan is the judge had an obligation to give that instruction. And I believe the defense attorney, there was no strategic reason not to request it. In fact, I believe it hurt the
But
defendant.
wasn't Pagan a second degree? I mean, I thought that was the issue. I mean, in other words, it was not a felony murder case, I don't think.
You may be right, actually. I don't remember. I sort of concentrated based on this case, so
Okay.
you may be right.
Okay.
I'm not sure, and I apologize for
No,
not
no,
knowing the case
don't.
as
That's
well.
fine.
I just remember that about that case, it was reversible error if the judge, and because the judge is required if evidence warrants it. And I would suggest that the evidence, the shooting happened very quickly. At the time, the shooter was running away.
Arguing that if they had gotten that instruction, the jury might have actually gone for a lesser offense than either kind of murder. Is that
Right, might have been manslaughter, which is what
Yeah.
I think, because he wasn't, and there was evidence he wasn't aiming at the victim, all this. So that's why I suggest that on 2 counts, reversible error and substantial likelihood, that instruction should have been given. Then, speaking of ineffective assistance, I had like 5 reasons that I found this attorney to be under Safran, he fell measurably below the ordinary fallible attorney standard. Involuntary manslaughter, we've already discussed. I don't have to do that again. But the humane practice, here's a young kid, I think he was in his early 20s at the time, who actually told the police in one of the interviews, I have to leave, I have a headache because I'm hung over from last night, which was the day of the murder. So he tells the police, I'm hung over, I have a headache, and there's no humane practice instruction at all. I'm sorry.
Did the, maybe I'm misremembering, did it come up whether there should be one and he didn't, the defense attorney, trial attorney didn't want one? Or it just didn't ever come up?
I don't think it came up. I think what came up was another instruction. There was one instruction that the judge did discuss with the attorney, and he said no. That might have been the humane practice one. You might be right.
The reason, because I thought, and the Commonwealth suggests that, in fact, some of these statements had the contents of them were supportive of the defense theory at trial. So the defense counsel, was part of his strategy to actually make sure that they were heard.
Right. No, that was included in the well-written brief by the Commonwealth. However, just because you can have, in this case,
You
to
can
use
have
an
your cake
expression,
and
you have
eat
your
it
cake and eat it too.
Okay.
You could have had all that evidence come in because there was no motion to suppress that was successful, and give the jury an idea about voluntariness, which is the key to the humane practice. How voluntary, because he's young, so you look at his age, his education, he wasn't well educated, his experience with the justice system, and his physical and mental condition.
But what did he want out of, he used portions of the statement to his advantage.
Right.
What were those portions?
About his intoxication.
Yeah, so if you're right, and the jury found that the statement was involuntary, they couldn't use it for any purpose, right?
Right.
So he's pulling the rug out from under himself.
Well, I just think that the statements were coming in, and the jury had a right to know about the humane practice instruction based on the voluntariness of the statements and his background.
What difference do you think it made in this case that they weren't told about that?
Because how much credit they gave those statements, because it wasn't just the exculpatory statements that came in, there was other parts of the statement, and that could have swayed the jury. We don't know, obviously, but
Well, the case didn't depend on his statements in any way, did it?
well, yes, he put himself at the scene. He talked about handling the gun. There were a few statements that I think hurt him. So
Now, there was no motion for a new trial here, was there?
No, absolutely.
We don't have any affidavit from the attorney explaining why he didn't seek it. Did he move to suppress these statements?
I believe he did, but I can't recall right this minute. But maybe there wasn't. I didn't write anything on that. So I'm going to say I don't believe there was a motion to
There's
suppress.
a motion to suppress the photographs, I
Yes.
see. I mean, the ID, but I don't see any
That was the
reference to a
motion.
motion to suppress the statements. So, and he chose not to testify.
That's true.
So the jury heard that he didn't do it only through those statements. I assume the jury heard that?
Yes.
So he was able to get in his claim that I was there, but I didn't do it.
Right. Which is helpful. I understand.
And there were eyewitnesses
Yes.
to the
Oh, yeah.
shooting.
Absolutely.
And were they discredited in
Well,
any
they-
significant way?
Yeah, a little. In other words, because they had contradictory personal observations and that was as part of the cross-examination. Another reason, I believe, the third reason is intoxication. Jury instruction should have been given. There was evidence that the group was drinking Hennessy whiskey out of a bottle. There was evidence that he told the police he was intoxicated and consumed marijuana. And that instruction was not requested. And that would have gone to the intent. And that, I can't imagine any reason why an attorney representing somebody on a murder case would not request an intoxication jury instruction on a case like this.
But given that the jury returned a verdict of felony murder only, how much difference does that make?
Well, it still goes to the intent. It's armed robbery.
Armed robbery?
It's a specific intent crime.
Yeah, of a specific intent to steal.
Right.
Was the defense here that he did not do it?
Yes. He was there, but he didn't do it.
And if he did it, he was drunk?
I guess you could say that, right.
But you'd have to show that
And
he
under the
was
influence
so
of
drunk he
marijuana.
did not have an intent to rob.
Right.
And let's assume that he asked for it. Would he be entitled to it? On this record, it has to be debilitating intoxication. Intoxication is sufficient to permit a reasonable jury to question the intent.
I think there was
Smoking
enough.
marijuana would not do it,
No.
I don't think.
But the combination of the whiskey and the drinking, I think it was enough to push it over the threshold.
Was there any evidence that during the course of his flight from the scene, he stumbled and fell on the ground or anything like that?
No, no evidence of that at all.
No evidence. Was there any evidence that he had any difficulty running?
No, no.
Can I focus your attention, if I could, before you run out of time, on the photographic arrays? Your suggestion appears to be that one group didn't know the other group, so there were at least some people who were really unable to give a description of the shooter or provide the defendant's name, so they were shown an array. And he was the only one in both arrays. There were shown two, not identified in the first. Could you
Correct.
tell me about why that's a problem in this case?
Well, I would say it was suggestive. He was the first group had his picture in it, and I think 7 other people, and they couldn't identify him. Then there's a second array, and he's the only one who's the same as the first array, plus 7 other people, and they identified him in that.
Pictures are quite different, though.
Well, they're different. I don't know, and I'm not saying quite different. I don't want to be controversial, but I think they're different, but not, what degree. He's the only one in both pictures.
His hair is different. So is the second
I
one?
mean, both arrays. I'm sorry.
Is the second photograph more like he appeared at the time of the events at issue?
I don't know. I just didn't think they were that different from the first. That's all. But I don't know exactly what he looked like the day of the event.
Was it the case, I can't remember this, that certainly some of the people who identified him, I'm not remembering, certainly one of them knew him.
Yes, one
And
of the
maybe-
gentlemen knew him.
Is that the only identifying witness who knew him in advance?
Yes, there was one person who knew him from Cape Verdean festivals and
Right.
things like
And then
that.
that was a male, and
Yes.
then there was a woman also, right?
Yes,
A
she was.
young woman?
She was the girlfriend of the person who was attempting to be robbed, and she said
She did not know him before.
no. That was the first time she met him that night when he asked her about her sneakers and things like that.
Right.
And she said she wasn't that far away from him, but she still didn't recognize him in the first array, but the second array, it was the same picture. Then there's the failure to object to that last-minute witness. And that last-minute witness wasn't on the witness list, and his testimony was somewhat important with respect to the chain of custody regarding a shell casing. His name was Officer Smith, I believe. And Officer Smith, without him, there may not be any link to evidence regarding shell casing.
The gun was not recovered, I guess.
No, but the shell casing was.
And, right, but it wasn't as if they could connect a gun found on the defendant to the shell casing.
No.
So what's the significance? I mean, it was pretty clear that shots were fired. So they found a shell casing, meaning it was a semi-automatic.
Yeah, in that casing, I believe Dr. Zane testified was related to the fragments they found in the victim's head. So it wasn't, so one could argue, well, maybe that shell, if there was a shell casing, one might have been able to argue, how do you know it's the one that relates to the one in the head? Because there wouldn't have been any chain of custody. He never would have been able to testify. So I think he was prejudiced, the defendant was prejudiced just by Officer Smith testifying.
I mean, I gather the shot was fired from about 6 inches away from his head, so you...
No, I'm sorry, Your Honor, with all due respect.
Sorry, I must be confusing this with another case, so...
Yeah, that's all right, but you're close.
One
The
person
eyebrow.
said 6
Yeah.
inches, but the forensic evidence was it was a
Right,
foot.
Judge, exactly, yeah.
But you would expect a shell casing to be relatively near. If it is a semi-automatic, it's going to expel.
And it's not his defense that the victim wasn't shot, it's just that he wasn't the shooter, right?
That was, absolutely.
So so
But
the
still,
prejudice
it's
is what?
another piece of evidence for the jury to consider. And why wouldn't you object under, as the Durning case? He wasn't on the list.
Was there any evidence that the defendant owned a gun that, like a 9mm or something,
Well,
that ejected casings?
There was evidence that the police went to his aunt's house, his so-called aunt. I'm not sure they were really related, but his Aunt Fernandez's house, I believe her name is. And they found a gun there under the mattress, but that was not related to the murder.
Okay, so there was no evidence that tied the defendant to any kind of a gun that might have ejected a shell casing at the scene?
Correct. Thank you. Yep. And lastly, with respect to ineffective assistance of counsel, the closing argument, there was the prosecutor referred to opinions that really weren't in evidence, whether it was the social media or vouching for witnesses, and there was, again, no objection. So if you take all 5, maybe they're not all winners, but if you take the totality of the circumstances of 5 issues, I think the court could consider that with all due respect.
You also argue that when the judge who will author this opinion reads the transcript, he or she is going to find that the judge was partial towards the prosecution?
I think so. I mean, it depends how you interpret some of the tone of the words. Like, I would say
So you're
when a
basing
judge...
it on the tone, which of course
Partly.
the transcript's not going to reflect.
No, you can't do that. But, you know, if you've been in enough... I've never seen so much judicial sua sponte assistance to help the prosecution, allowing leading questions, covering, assisting with questions, being perhaps a little more polite to one side than the other, helping, like there was one time when they were trying to get in a video, and they just weren't laying their proper foundation. So the judge came in and says, is it a fair and accurate representation? So gave some hints to over objections. And the judge actually asked questions about the gun, too. So I just thought it was a little over the top.
If somebody were watching this trial, would they get the flavor that the judge might have thought the prosecutor was not as competent as he or she should have been?
Well, I don't know either. That's always a possibility, or the judge was just trying to assist the prosecution.
All right,
Oh, I see my time's up. And thank you very much, and I'll just rest on my brief on the 33.
thank you.
Okay, thank you.
Ms. McKenna, good morning.
Good morning. If it please the court, Gail McKenna, Assistant District Attorney for the Commonwealth. I think to begin with, speaking about the arrays and the defendant's 33E argument concerning the arrays. In this case, one of the witnesses, Walter Crumley, knew the defendant in advance, had known him for a couple of years. They were friendly. He was able to identify the defendant because he knew him. When he was shown the first array, which had 8 photographs, he deliberately did not identify the defendant even though he saw them in the array.
What do you mean deliberately did not identify?
He said that he, because he was afraid, he did not, even though he saw the defendant's picture there, he decided not to say anything.
Were they, I just don't remember this, were they shown on 2 different dates?
They were shown about an hour or so apart. In one instance, the police went to his home and showed him an array, and then they brought him down to the police station and they showed him another array. One of the problems was that the photograph that they had wasn't a contemporaneous representation of what the defendant looked like.
First one or the second one or both?
The first one was not contemporaneous. He had very long hair in the first one, and at the time of the incident, he had very short hair. So when they went back to the station, they had 6 photographs, including a contemporaneous photograph, that they then showed sequentially, which was kind of interesting. The first one was everything on a couple of pieces of paper, and the second one was one where they showed things sequentially, one at a time, and then laid the 6 photographs out in front of him. But, I mean, he knew the defendant. He was able to identify him by name. He had met him several times before over the prior years. So that's what that identification was about. The other identification that was challenged in a motion to suppress was one by a woman named Christine Trinflaglia, who was present at the scene. She didn't identify from the first array, which had 8 photographs. There was a second array. The police went to her workplace the following day with another array. This one had also 8 photographs in the contemporaneous photograph. And with the contemporaneous photograph, she immediately identified him. So those were the 2 that were subject to the motion to suppress. There were 2 additional identifications, one by someone named Hannah Grinrod, who was the victim of the armed robbery's girlfriend. She was the one who the defendant stopped, commented on her sneakers, and then sat down. There was no motion to suppress having to do with her. The other was a young woman named Jamie Lee Sylvia, who saw the defendant when he arrived at the party, and then was standing there, and the defendant and 2 or 3 others came in. I guess almost knocked her over. And from her vantage point, she was able to see the defendant's face and see him hold the gun to Sheldon Santos's, who was the victim of the armed robbery, to his head.
Wasn't there a girlfriend of Sheldon Santos that also?
That was Hannah Grinrod, the person I mentioned third.
Okay.
And the motion to suppress didn't go to those two people. Now, on appeal, as part of his 33E, the defendant suggests that the identifications overall were so unreliable that the court should order a new trial or reduce the verdict. However, here, although defense counsel pressed hard at trial and cross-examined everyone on different issues having to do with consumption of alcohol or sharing information on social media, none of those issues, he wasn't able to establish evidence based out of those issues. He asked the questions, but nothing came to fruition. So I would suggest that it would be inappropriate to reduce the verdict under 33 based on that
Now, if-
particular.
If that had happened today, he would be entitled to part of the model eyewitness instruction, which would warn the jury about the dangers of the same person being shown twice in a photo spread, correct?
Well, he would, Your Honor, but I think that, you know, in reviewing some of the new literature on sequential versus non-sequential, and, you know, I'm really not sure where the social science is still on that. I think it's still developing.
The issue is not sequential, non-sequential. The issue is the fear is a source memory, that if you see somebody if somebody's in one photo spread, you don't identify him, and then you see that same person in the second photo spread, and he's the only person who you've seen then of course you'd say, I've seen that person before, and there is an issue of source memory. I think it's addressed in the model instructions. It is a problematic issue. You would argue, I guess, that it was justified here by the different photographs.
Well, you know, and I think.
By the different, I mean, not different photographs, but by the different hair, the physical different appearance in the photographs.
Well, and we're talking two of the four identification witnesses. One knew him anyway. The other one, the testimony at the motion to suppress was on the first one, she kept staring at that picture but didn't do an identification. She was there was a proper advisement under Silva Santiago, this court's instructions on what witnesses should be advised of prior to making selections, and I would say she was just appropriately reticent. As soon as she was shown the other one, she made her selection, but I think that it's important that it's a different picture. It's not the same picture being shown over and over again. So I don't know how valid the source memory issue is in that circumstance where it's an entirely different photograph. At the same time, two other witnesses identified the defendant on the arrays that they were shown. I'm not sure which picture was in either of those arrays. But we had identification by two other people without having to show two arrays, which is why that part of the motion to suppress identification was waived.
And I gather there was no request for an instruction that would vary from the Rodriguez instruction that would address the photographs being shown twice, correct?
I did not review whatever submission the defendant made, but there was no objection at the end of the instructions. I know that from reading the transcript. So, you know, I feel pretty safe in saying no, that there wasn't. I don't know that if people were sort of predicting that particular piece of it about using different photos. And as I said, that would apply in this case to just one of the witnesses. And we do have a full explanation from that witness about why she was reticent on the first one and why she made the selection on the second, and it was because the photograph was different, more contemporaneous, and reflected the way the defendant looked now, not the way he looked in an older photograph with long hair.
How much older was that photograph? Do you remember?
That I don't know. I know that his hair was long in one. I know that his hair, it was a contemporaneous photograph in the second one. So I can't answer that, Your Honor.
At the time of the crime, he had short cropped hair?
Correct.
And he was not wearing a hat during the course of the shooting?
He was wearing a hat during the course of the shooting.
Oh, so why would the hair matter if the person's observation of him would have occurred only when he was wearing a hat?
Well, this witness said it mattered to her.
Didn't you say that did he have dreads or braids in the first picture?
No,
It was just longer hair.
longer hair.
Okay.
That was the distinction. And as I said, you know, at the motion to suppress hearing, the trooper testified that she was focused in on that. It was at the bottom of the page and focusing in on that. But, you know, she had the advisement that this court says to give, which, you know, don't make a wrong identification, don't guess, and she did what was appropriate. And when she saw a contemporaneous photo, she selected it within 15 seconds.
Was the longer hair, you know, like at chin level, do you know, jaw level?
I don't know, Your Honor. I've looked at the arrays that are in the record appendix, and they're kind of they're really hard to discern. They're not good copies that I have, so I can't help you with that. I apologize.
But I assume we'll have the originals for our decision, correct?
We
I'm
can get
sorry?
them.
I assume we'll have the actual photographs as part of our record.
Well, I think if you call them up from the trial court, then absolutely that you would, and you can look at those for yourself.
The closing argument reference to social media not influencing the identifications.
Right. That was firmly in the evidence. Apparently, well, people were using different social media. The defendant was using MySpace, and the participants at this party, the Wareham kids, were using Facebook. One of them, her name was, oh, it escapes me now, not one of the 4 ID witnesses, but one of the witnesses said that she went on Facebook to look for someone named Justin, who was friendly with someone else at the party, and went on Facebook to look for him. The defendant was on MySpace, so he just wasn't on that. And, you know, the fact that certain people knew the defendant's name, there was no evidence that there was ever a link between the name and the face. So the fact that people are using social media, although the questions were asked, there were no affirmative answers that there was any type of link up between name and face through the use of social media. People were using different platforms.
And was there any evidence that anybody had seen the defendant's photograph on social media?
There was not. There was not. And he was arraigned after the identifications were made, and at arraignment, he had something over his face. So that wasn't a possibility either. That's all in the evidence.
Could I just go back to the photographs? Going back to the memorandum by the motion to the judge who did the motion to suppress. It says that, it's pretty clear from this that the officer who was showing the photographs to Tranfaglia knew which was there was a photograph in there he wanted her to identify, because here's what the judge says. Trooper McGrath told her, think about it. That's the first one after she'd been looking at it. Think about it. If she saw the person, she should do the right thing.
Well, and
Is that not problematic?
because she didn't. You know, I think this shows that she wasn't influenced at all.
This is after she said, I don't see the shooter.
And she still,
And then he says, think about it. Do the right thing.
and she did the right thing. She followed this court's instructions, which are what she was read. And she didn't select someone because she wasn't sure.
And then
And that-
in this case, the next day is when she made it from a different
Correct.
array.
Correct.
Okay.
Yeah, I mean, that wasn't my favorite thing that happened either, I'll be perfectly honest.
It's not going to be part of our new protocol to be adding that if
Well,
the
I was
witness does not
grateful for-
identify them, the police officer should say, do the right thing. But as
Well,
long
do
as
the
as
right
long as
thing
you
can also
recognize
be
that.
exonerating someone, and based on the protocol that she was read, that was part of do the right thing. So I was grateful for the protocol. She was read the protocol. She read it to herself. She signed it, and she did the right thing. She followed the protocol. So, you know, it is what it is. She didn't identify anyone at that point, and she waited until she saw a contemporaneous photograph the next day.
For her, what was the time differential between the first and the second?
It was the next day. She was at work. She went into the break room. The police showed up without an appointment unexpectedly, and as the trooper testified, within 15 seconds, as soon as they showed her, after giving the advisory once again, she selected him.
One was at 5 o'clock in the afternoon, the next one was 2 o'clock, so it's pretty much a day.
Yeah, pretty
24-hour
much
day
a
almost.
day. So, if there's anything else the court is interested in hearing on, I'd be happy to. Other than that, I would thank you all for your kind attention and respectfully request that you affirm the conviction.
All right, thank you.
Thank you all very much.